Timeline of the Pakistan Tethyan Copper Company, TCC, Reko Diq's dispute. July 1993. The government of Baluchistan and BHP Minerals, Australia, signed the Chaghi Hills Exploration Joint Venture Agreement, CHEVA, giving BHP 75% interest in Reko Diq's copper-gold exploration and the provincial government 25% with a 2% royalty. This agreement marks the origin of the Reko Diq project in Chaghi district, Baluchistan 1. April 2000. BHP suspends work and transfers its Reko Diq stake and obligations to Mincor Resources, a smaller Australian firm. The government does not object to this transfer, despite the opportunity to seek new bids after BHP's withdrawal too. 2006, Mincor is acquired by Tethyan Copper Company, TCC, a joint venture between Barrick Gold, Canada, and Antofagasta, Chile, which thereby takes over the Reko Diq project. That same year, CHEVA's legality is challenged in the Baluchistan High Court on various grounds: violations of law, improper registration, and relaxation of rules. But the court dismisses the challenge and upholds the agreement as valid. 2007 to 2010, TCC negotiates with provincial and federal authorities for a mineral agreement to develop the mine, and by 2010 it completes a bankable feasibility study for Reko Diq. The study outlines a large-scale mining operation, but some Pakistani experts believe TCC's figures understate the deposit's potential. Feb 2011. With the feasibility study in hand, TCC formally submits an application for a mining lease to the government of Baluchistan 5. Nov 2011. The Baluchistan government rejects TCC's mining lease application, citing several stumbling blocks. Officials insist that any refining and smelting of ore must occur in Pakistan, not abroad as TCC planned. Royalty rates should be increased, the financial model should be revised, and local population interests must be better protected. By this time, TCC had already invested around $220 million in the project. Novdec 2011, TCC initiates legal action in response to the lease denial. On November 6, 2011, a petition is filed in Pakistan's Supreme Court to prevent Baluchistan from issuing the Reko Diq lease to any other party. TCC initially claims $11.43 billion in damages for its sunk costs and lost. The ICC proceedings are later stayed pending the XID outcome. June 2013, Pakistan's Supreme Court announces its verdict in the Reko Diq case while the ICSID arbitration is underway. The court declares the 1993 CHEVA agreement void ab initio, void from the outset, and against public policy, ruling that the Baluchistan government had exceeded its authority in signing the deal. The judgment holds that TCC has no legal entitlement to the Reko Diq lease or the underlying mineral rights. Feb 2016, the ICSID tribunal, arbitrating TCC's treaty claim, issues a detailed draft decision on jurisdiction and liability. It affirms that ICSID has jurisdiction and that TCC's investment was protected under the BIT, rejecting Pakistan's objections. Crucially, the tribunal finds that Pakistan's 2011 denial of the mining lease amounted to expropriation and a breach of Pakistan's treaty obligations, given TCC's legitimate expectations from the 1993 joint venture and subsequent assurances. July 2017, the ICSID tribunal renders its final decision on the merits, confirming Pakistan's liability. It concludes that there was no corruption or illegality in the CHEVA, directly contradicting the basis of the Pakistani Supreme Court's voidance, and that TCC had every reason to expect the mining lease would be granted. All of Pakistan's allegations of wrongdoing, including claims that TCC tried to bribe Baluchistan officials, are rejected, clearing the way for an assessment of damages. The tribunal orders Pakistan to pay $5 billion in damages to TCC. The award includes about $4.09 billion in compensation plus $1.87 billion in interest. At the same time, in a separate contract-based arbitration in London, Pakistan faced roughly $4 billion in potential liabilities to TCC's parent companies as a consequence of the Chaiva breach. Hog 2019. Rather than immediately pay the award, Pakistan moves toward a settlement. Prime Minister Imran Khan forms a special committee in August 2019 to engage with TCC and negotiate an amicable resolution. Over the following months, this committee, aided by international legal and financial advisors, including Whitecase and Lazard, works on a proposal to revive the Reko Diq project and offset the hefty judgment. Nov 2019, Pakistan formally files an annulment application at ICSID, seeking to overturn or reduce the July 2019 award. Meanwhile, TCC begins moves to enforce the award in various jurisdictions. By late 2019, Tethyan has initiated enforcement proceedings in the United States, Australia, and the United Kingdom, including the British Virgin Islands, to identify and seize Pakistani commercial assets up to the value of the award. Nov 2020. With the award still unpaid, TCC petitions the High Court of Justice in the British Virgin Islands, BVI, to attach assets of Pakistan International Airlines, PIA, as part of enforcement. On November 20, 2020, TCC targets PIA's offshore subsidiary, PIA Investment Limited, incorporated in BVI, which owns the Roosevelt Hotel in New York and the Scribe Hotel in Paris, among other assets. In parallel, an ICSID ad hoc committee grants Pakistan a conditional stay of enforcement. Pakistan must post a 25% guarantee, around $1. $5 billion of the award amount within 30 days for the stay to remain in effect. DAC 16, 2020. Pakistan fails to meet the ICSID security requirement by the deadline. Consequently, the BVI High Court issues ex parte orders to freeze and attach PIA's assets, including its interests in the Roosevelt and Scribe hotels, as an interim step to enforce the ECSID award. This development raises alarm in Pakistan, given the risk of losing valuable overseas properties. By late December, Pakistani officials indicate they are actively negotiating with TCC to settle the dispute and forestall further enforcement. John 2021. In the wake of the BVI asset attachments and another unrelated case involving foreign judgments, Pakistan's government instructs state entities to minimize foreign-held assets to avoid seizure. Negotiations with TCC intensify, aiming to resolve the matter out of court. May 25, 2021. Pakistan scores a legal victory in the BVI. The High Court of the British Virgin Islands sets aside the earlier attachment orders, ruling in favor of Pakistan and unfreezing PIA's assets. The court nullifies all ex parte orders that had been obtained by TCC, and the receiver appointed over the Roosevelt and Scribe hotels is removed. As settlement talks continue, March 20, 2022, a major breakthrough. Pakistan announces a comprehensive out-of-court settlement with Barrick Gold, TCC's parent company, to finally resolve the Reko Diq dispute. Under the deal, Pakistan avoids the looming cash and toll. $11 billion in total penalties, the $6 billion ICSID award plus interest, and potential $4 billion in contract claims. In return, the Reko Diq project will be revived and developed by a reconstituted consortium led by Barrick. The settlement unwinds the dispute. All legal claims by TCC are to be withdrawn, and the ICSID-ICC awards will not be pursued. March 2022. New Reko Diq agreement. The revival agreement redefines ownership of the mine. Barrick Gold will hold 50% of the project, while the remaining 50% is split among Pakistani stakeholders. The government of Baluchistan will receive a 25% share, held via a provincially owned company, and 25% will be held by federal state-owned enterprises, OGDCL, PPL, and GHPL, each getting 8.33%. Notably, Baluchistan's share is free-carried. The federal government will finance the provincial share of capital and operational costs, so the province incurs no expense but will receive dividends and royalties from its stake. Chile's Antofagasta plc, Barrick's partner in TCC, chooses to exit the project under the settlement, agreeing to withdraw its $9 billion claim, in exchange for a $900 million payout, which Pakistan's government and Barrick will arrange. Pakistani officials hail the deal as a win-win. In addition to averting heavy penalties, it is expected to bring $10 billion in new investment and create about 8,000 jobs in Baluchistan during mine development. December 22. Pakistan's Supreme Court, upon a presidential reference, gives its green light to the Reko Diq settlement. A larger bench of the court opines that the March 2022 deal does not violate the 2013 Supreme Court judgment or Pakistan's laws. The court's advisory judgment holds the new arrangement lawful and in the public interest, removing any legal ambiguities. This clears the final hurdle for implementing the settlement, since the original CHEVA had been nullified by the court. Now the fresh agreements are explicitly validated. Let's now review what went wrong. 1. Lack of transparency in licensing and regulatory oversight. 2. Pakistan's government failed to enforce due diligence and stakeholder review. 3. Foreign firms use legal means to claim investor protection under international treaties. 4. Local benefits, employment, infrastructure, royalties were ignored in the early agreements. One common trick used by foreign firms includes this strategy. A company expresses interest, surveys the site, and later reports no viable resources. The same group, through another front company from a different country, applies again. Corrupt officials and political elements facilitate the contract discreetly. Valuable national resources are locked or passed off under poor terms. As of 2023, Barrick Gold leads the project again under a new agreement. Construction is expected to start in 2025. Pakistan avoided paying the massive fine through renegotiation. However, governance reforms and project oversight remain questionable. Follies of the Pakistani government: entering contracts without legal preparedness, weak institutional capacity, and corruption, undermining national interest due to lack of strategic vision, delayed realization of international legal consequences. Recommendations: strengthen laws related to natural resource contracts, transparent and accountable tender processes. Establish a sovereign resource authority with legal and technical expertise. Ensure community involvement and long-term benefits for Balochistan. In conclusion, the Reko Diq saga is a costly lesson. It exposes how global corporations exploit weak states and how governance gaps become national liabilities. It is now our responsibility to ensure that Pakistan's wealth serves its people, not just foreign profits. Thank you for bearing